Hey, B. I'm not talking. I'm not talking unless y'all giving me likes, you're commenting, you're sharing, and you're subscribing. You hear me? Okay. Mm-hmm. Carry on. Listen, we are back. We're back for another episode of Court. It's messy. All right. And y'all know we back with one of my favorite judges, and that is Judge Timmy Long Hayward, period. So let us go ahead without further ado. All right. Let us go ahead and get right on into this video to see exactly what the heck took place over here in this damn courtroom. Let's check it out.
Hello. Is Mr. Lotta is with you at the computer,
Yes,
correct? All right. All right, so this is State of Georgia versus Benjamin S. Lotta. Mr. Lotta is represented by Mr. Moody, Bradley Moody, who's with him. This is case 2024 CR 00187. This is a motion to modify bond conditions. They are present, and the state is represented by Ms. Is this Ms. Ponder or Ms. Hayward?
Yes, Sharon, I'm handling this case.
All right. Thank you. All right. So is the state ready to present?
Your Honor, the state is ready. I just want to get some clarification. It's my understanding, and counsel, you can correct me if I'm wrong. It's my understanding that this is on for a motion to modify bond so that Mr. Lotta can have communications with his child. Is that correct?
That's correct, ma'am.
Okay.
All right. How old is the child, Mr. Moody?
2, Your Honor.
All right. And okay, so that's gonna make it a little difficult. What is so y'all tell me, what's the plan? Because if the mother of the child is the person who's the victim, alleged victim in this case.
That is correct, Your Honor. It is our understanding that Miss Sanford, she is the mother of their 2-year-old child, and it's my understanding that Mr. Lotta is requesting contact with his 2-year-old daughter via Zoom. It's my understanding that Mr. Lotta resides here and the mother does not reside in the state of Georgia.
That's correct, Your Honor. The mother resides in New York. Currently, Mr. Lotta and the mother of the child are going through the process of legitimation, or at least Mr. Lotta is going through the process of legitimation in New York. And in terms of custody and visitation, we've an impasse in that the court in New York will not hear the matter of custody and visitation based off of the no contact order from here in Georgia in Clayton County. So we're trying to make some arrangement to allow where Mr. Lotta would be able to ultimately have some sort of visitation with his daughter.
Okay. Yeah, but this is complicated because the issue was harassing phone calls. The mother would have to facilitate the child getting onto a Zoom and manage that. And so what y'all are asking me for is to allow no violent or harassing contact limited to Zoom calls with the child. But that means that the mother has to manage it, and she's really not under my jurisdiction.
And Your Honor, it's my understanding that Ms. Sanford does not want to have communication with Mr. Lotta. Is the reason, it's my understanding that counsel filed a motion to modify bond so that he can have contact with his daughter. As it's the state's position based on information that I did receive from Ms. Sanford, she's not comfortable with speaking to Mr. Lotta, and she does have the child. So at that point, the state will defer to the court.
And the legitimation action in I guess whatever the family court is, in what part of New York is this?
This is in Queens, New York, Your Honor, and it's not a legitimation.
The Supreme Court, right?
Yes.
Okay. So the Supreme Court in New York is not going to have, they're not going to even entertain the request for visitation legitimation unless I remove the no contact provision. Is that what I'm understanding?
That is my
That is
understanding.
correct.
That's not correct, Your Honor. That's not correct.
Miss
Ms.
Sanford,
Sanford.
give us
Ms.
one
Sanford,
moment,
hold
please.
on, ma'am. I'll hear from Ms. Sanford, but Ms. Sanford, hold on give me a minute.
This is pretty
Because I'm
common.
trying to understand.
What did Miss Sanford do? I'm confused. What do y'all mean, Miss Sanford? Hold on. Like what?
So at that point, the state
I
will
didn't hear her say
defer to the
nothing.
court.
And the legitimation action in the, I guess, whatever the family court is in, what part of New York is this?
This is in Queens, New York, Your Honor, and it's not a
That would be
legitimation
the Supreme
process.
Court, right?
Yes.
Okay, so the Supreme Court in New York is not going to have, they're not going to even entertain the request for visitation legitimation unless I remove the no contact provision. Is that what I'm understanding?
That is my
That is
understanding.
correct.
That's not correct, Your Honor. That's not
Oh,
correct.
that's her. There
Sanford,
she
Miss
go.
Sanford, give
Okay.
us
Ms.
one
Sanford,
moment,
hold
please.
on, ma'am. I'll hear from Ms. Sanford, but Ms. Sanford, hold on give me a minute.
This is pretty
Because I'm
common.
trying to understand, because some of this, I mean, I can say a lot of things. I order a lot of things, but Ms. Sanford is literally outside my jurisdiction. She doesn't live here. The child is in New York. The only person I have control over is Mr. Lata. And
And
with
Your
that
Honor,
being said, I can order that Mr. Lata can have no violent or harassing contact and limit it to Zoom or text. But as far as whether that happens, that has nothing to do with me.
well, yes, Your Honor, and that's exactly right. I completely agree with that. And the screen just went out. Can you still hear me, Your Honor?
I hear you.
Okay, sorry, the screen went out. So I completely agree with that, and that's all we're asking for is the relief to allow the court in New York to make that custody arrangement or make that visitation arrangement. So I mean, as of right now, we're just at, I mean, we're at an impasse as to any progress in either of these matters. The case here in Clayton County or the family law matter in New
Is it
York.
raining, John?
I get that, but the issue that I have is the action you're wanting me to allow is for him to make essentially phone communication with Miss Sanford for the purposes of seeing the child.
Yes, Your Honor.
The alleged offense is based on harassing phone communications.
Yes, Your Honor,
And
I
so-
understand that. I mean, this is an event from March 17th of 2023. At some point, at some point, these two people are just going to have to accept that they do have a child together. I mean,
Right. I mean-
he's not never see his child.
I get that. Here's the issue that I have
Yes, Judge.
is a lot of people have babies and children together without first thinking whether this is somebody they can
Very
stand
true, Your
over the
Honor.
long term.
That's right.
And this is essentially what I keep getting, like it's not really my bailiwick. I'm state court. I don't have to do family law. Thank God. Because when I was a staff attorney in the family law division in Fulton County, I knew then that was not what I wanted to deal with because the most volatile practice is family law. That's where you give an inch, they'll take a month. If you say you can have a little bit of contact, then all of a sudden my words get weaponized and the judge said, and that's really not what this is because I can't order Miss Sanford to do anything. The only relief I can give is I'll say no violent or harassing contact. But the problem that I have is the contact that you wish to enable is what is the basis of the charge. And I just don't, I've never had a court with a jurisdiction over what I have say that they needed me to do something in order for them to do something.
Yeah.
Here, if I say no harassing or no contact, a superior court can say, because they're a court of general jurisdiction, hey, I understand this order, but I'm going to order these specifics with respect to the no contact. I recognize it, but I can order this because these people are before me. The problem that I have here is even if I say this, I can't control then what happens. And if this leads to another offense of harassing phone calls, then I've enabled it. I just want people to start thinking more about okay, it feels good right now, but do I really want to have a baby with this person? Because these issues are coming up a lot.
And is it possible?
Let me hear from Miss Sanford for a minute. Miss Sanford, raise your right hand for me.
Yes,
Hold on, Miss Ponder. Do you solemnly swear or affirm any testimony you give in this matter will be true?
Yes, I do, Your Honor.
Okay.
All right, so tell me about your concerns, Ms. Sanford. Don't really go into the what happened, underlying offense, because I don't, that's not what's on the table, but tell me about me giving context.
Yeah.
So I would like to first express I vehemently oppose. I'm not consenting to any access between Benjamin Lotta, the defendant, and is the 2-year-old, our daughter. As it stands right now, Your Honor, I have many pressing concerns. And what I'm surprised that has not been brought up already is that Mr. Lotta has an outstanding, and I'm going to be careful with my words because of how it's entered, but he has an outstanding warrant here in New York when he has been evading the police for the last close to 3 years by not answering that warrant. He has refused to come to in-person proceedings. His family court attorney makes excuses for him by just saying he can't come because he would get arrested. He has not tried to turn himself in. They have said that they cannot find it. But it has been stated on record several times. My previous attorney has been able to confirm he is a wanted person in New York. The terminology of it, with it being a warrant, it's not the exact terminology, but that it is an equivalent because the police department issued it and not the state. So that's why when you search it, it does not appear, but he is in fact wanted here in New York City for an offense here.
Ooh.
Now,
What they call it up there, a detainer?
no, it starts with an I.
Okay.
But he is.
So you're objecting to any contact?
Yes, but I have other concerns as well.
Well, let me satisfy what I need to know. The child is fully in your custody and control.
I have sole legal and physical custody of time. Yes.
Okay, there would be nobody else who could facilitate the contact over Zoom, but you.
No, because one, Mr.
Don't
Lotta
have to
has
tell
made.
me why. If you have full custody and control and there's nobody else, that's fine. The less that the child's information is put out there, the better. I don't like.
I also want to just bring something else out there that in family court, because I'm pretty sure this is something that Attorney Moody would be prepared to say today based off of other testimonies made. The defendant has made requests for social workers to do the I guess the Zoom exchange. Now, in the past, I have already consented to Zooms. I have signed stipulations granting the defendant access, but I withdrew it because one, he did not have Georgia's permission, and two, he was actually actively abusing government agencies during that process. And just to talk about my safety concerns when it comes to the defendant and the defendant has sworn under oath in a criminal trial in Fulton County that he instructed someone to call CPS with false allegations stating that I was going to kill my daughter. And this is in
Okay. This is all I need to know. Ms. Sanford, you're not testifying for this, Ms. Sanford. I don't want to know anymore because what I don't want is.
The reason why I'm bringing that.
Well, the judge is trying to be very careful because it appears that that's not her jurisdiction and this ain't family court just a bit. So
up is because I don't want to
Sanford.
Around my
this
daughter.
Is what I'm saying is y'all start testifying whenever it's a family law issue. Y'all start testifying for whatever the next hearing is. I don't need to know all that. What I need to know is whether it makes sense for me to grant the modification. I think I've heard enough where I'm not comfortable granting the modification. I think what, Ms. Pond?
Is it possible if I can have a breakout room with the court as well as with defense counsel?
Please.
Okay. 1 second.
that man said, please.
Hey, Judge James Fulton just checked in.
All right, Mr. Fulton. Yeah. I didn't see Mr. Fulton's name on here, so he must be for 1 or 2 o'clock. So,
Relax, Mama. Please go have a seat, baby.
let's see. Okay, so I'm gonna put the courtroom and Ms. Ponder in breakout room number 1, and then I'll join. And Miss Sanford, I'm not real comfortable with your daughter's picture being on. She's a minor, and this gets broadcast.
I know that's right.
You know, you got her picture up behind you. I'm not comfortable.
I'm so sorry. I thought her face was blocked because on my end, I can only see her elbow.
I can see both of her, both pictures.
Oh, wow. Sorry.
Yeah.
On my end, I put it at an angle where I can only
Yeah,
see.
I got you.
Girl,
But I'm,
bye.
yeah, just not comfortable with that.
No, thank
All
you.
right.
I'm not either. Thank you. Thank you. Is that all you see now? Because on my end, I was only ever to see her arms down.
Yeah, it's better.
Thank you.
And the issue is that both parents seem to lose sight of the fact that there is a vulnerable child.
I think that lady did want that man to see that baby like, nanny boo boo, you might well see a picture of her because you ain't gonna never talk to her, you motherfucker. And let me tell you something. Listen, if you done sat up there and said that I was finna kill my child, well, you know, well, I was finna kill my child. I ain't never tell you no shit like that. This all you is gonna get her a glimpse, a photo. I know that's right. Just a little piece, but anywho, girl.
In the situation, and it becomes very performative. Everybody's fighting and yelling and going at each other, and nobody. Miss Sanford, you can look at me all you want to, but I've been in this game for so long. The pilot program for Fulton County Family Court, I was one of the staff attorneys who helped to
implement that.
Get some of the forms done, who sat through mediations, who trained extensively in family law, and then decided I never wanted to do it because what people do is they weaponize the child, and they don't think. I work alone. If I need you, I'll let you know. They don't ever think about what it means to a child to have parents who fight continuously. Now, this is the issue. At some point, y'all thought it was a good idea to sit down and exchange bodily fluids and have a child. At some point, this person who's on the other side of the V made sense to you. Now, unless it was an arm's length transaction where this was done through a clinic or something, or this was a surrogacy issue, but I'm not getting that. I'm getting that you all chose to have a child. As a child of divorce, and it wasn't even a contentious divorce, I will tell you that both of you, until you learn how to co-parent, are going to ruin your child. I'm just gonna say it.
But see,
you're gonna ruin
wait
this
a minute, Your Honor, because I feel like I would like to have additional reasoning though. And you are not giving me that in this moment, and I understand a bit why. But I want to know like more, like there may be valid reasons as to why she may feel like she doesn't want him around her child at this time outside of the warrant that he got, outside of him saying that she was going to harm the child or whatever. Like what else has he brought harm to the child? And if we're not hearing that because those things didn't happen and she's being petty, wanting to just keep the child away from him, and then, then whatever the judge is saying, she right. Okay.
Because she is going to understand that she has two parents, and if she's denied the time to be or the opportunity to be with one or the other parent, she's going to resent that. I grew up without my father in my life, and I'm going to tell you, I didn't resent my mother. I knew the circumstances, but I did resent that he wasn't present, and I grew up without him. So what I tell you is at some point, you got to put your claws in. You got to have a little bit of humility, and you got to listen and structure this in a way where y'all may never like each other. You may never deal with each other directly, but y'all have got to figure out a way where this child doesn't feel like half of them is not a good thing.
Yeah.
The child is always going to know that they have a father and a mother. And if they don't have access to one or the other, it's going to hurt. Now, Ms. Sanford, you came on here and I'm listening to you, but as a mother, I would have
Sure.
never shown my daughter's picture. I would have
It
never
was
said
not
your daughter's
intentional, Your
name.
Honor.
You
That
said
was
your
not
daughter's
intentional.
name multiple times. You've shown the picture multiple times. That to me is performative.
Your Honor, may I just
Ooh.
intervene because you made a few statements that are very inaccurate, okay?
Y'all
First
didn't
and
choose to have a baby
foremost-
together.
First and foremost, let
Y'all
me
didn't
just
choose to have
make
a
it
baby
very,
together.
let me make it clear on
Y'all
record.
didn't choose to have a baby
I
together.
chose to have my daughter. He told me to have an abortion. And I'm now, let me just start because we're going into things that's not relevant and I don't speak
No,
about these
Ms.
things until
Sanford,
in the
I'm
presence of
not
my
going-
daughter.
I'm
Your
not
Honor,
Ooh, baby, now she over here trying to get a judge too much. Like, let me just start. Let me just, okay, because we're going through things that we don't. Let me be very clear. Ooh, Your Honor, I want to hear her for a little piece. Just let her cook for a little second, and then if she ain't gonna cook, then you need to cook her. But give her a little piece of a second.
court. I'm not doing
Your
this.
Honor,
What I'm
I
saying to you
offered, I heard.
okay, so to the extent that
She done got
I
muted.
am holding up the family law court from making a decision in this case, I will grant a very limited
Your Honor, may I
modification.
please
Ms. Sanford,
mention what I was going
Ms.
to say?
Sanford,
You
Ms.
made some
Sanford.
statements and I would like to.
I will grant a very limited.
I do feel like, Your Honor, you should hear her out, and I don't feel like you're hearing her out. It could potentially be maybe the judge has read a lot of the case already, and some of their other case they may have going on. Maybe she had access and read some of those things. I don't know. Or maybe she's trying to protect herself when it comes to, like, the family law and the girl about to go into a spill that don't got nothing to do with the judge or something. Dang. I want to know more now.
Modification of my order. It is to be no violent or harassing contact, no direct contact. Any contact will be subject to text messages. If there is Zoom contact, the Zoom has to be recorded so that there's a record for the court. No physical contact, no in-person contact.
I'm going to appeal it.
You can do whatever you want to, Ms. Sanford. No
She
We
keep
had
muting
5
her. Maybe I'm
negotiations
screaming.
that he declined.
so that the family law court in New York can make a
She
decision,
keeps
because I don't
muting her.
have jurisdiction over family law. My jurisdiction is literally limited to this particular misdemeanor offense in Clayton County, Georgia. With that being said, Mr. Lanta, let me explain to you, outside the very narrow confines of what I've ordered, let me explain what happens if you violate. The possibility exists that you could have your bond revoked and you could remain in jail here in Georgia in Clayton County until your case is tried. There also is the possibility that you could be charged with additional misdemeanors or felonies, particularly the felony of aggravated stalking, which is punishable by up to 10 years in prison, a $10,000 fine, or both. I'm not just giving you these cautions. Everybody who has a bond and a case where there is a victim on the other side, and it's not a traffic offense, I go over these bond conditions and the issues of bond with them. So with that being said, I will limit contact to text, to Zooms if they're recorded, and no in-person, no telephone, nothing that can't be seen by or reviewed by a court. No, that is the limitation that I have, so that the family law court in New York can address these issues and can make a determination that might be permanent between these parties, because I don't have jurisdiction on that.
Your Honor, it has been suggested in the family law court in New York, the possibility of having some physical contact as supervised.
No, that has never been discussed. That has never been discussed. And I'm not getting the opportunity to speak.
I've done all that I can do. I would presume that a superior or Supreme Court in New York, which has jurisdiction over family law, can make whatever decision they want to make. And at some point soon, I hope, this case will be tried or resolved through a plea, and my jurisdiction over these individuals this individual will end. And so my decision is limited by the fact that I'm not holding this case forever. If you talk to the state and y'all can pre-try this case and y'all get it resolved, that's fine. If we put it on a trial calendar and it goes to trial, that's fine. But I'm not going to have the level of oversight over these parties that the family law court will. So they can do what they want to do.
So I hope
I
they
won't be
understand what she's
offended.
saying.
I promise you. So with that being said, draft the order. I'll sign it and get both copies to both parties.
Your Honor, may I please clarify one statement?
What statement, Ms. Chair?
Thank you, Your Honor. I want to make one thing clear because you did give us a well-needed lecture, but I want to make one thing
A
clear.
well-needed lecture.
The
Bitch.
defendant was offered not one, not two, but 5 custody and visitation negotiations from me when I was pro se and represented. He declined all of them. And we're talking about over the course of 3 years, the child is only 2. I have also signed 2 stipulations for him to have access to the child. Let me speak, please. I have signed 2 stipulations for him to actually have access to the child. He never asked permission from the state of Georgia to get it. So it's not performative. There are things that has happened between then and now where he has put my child and myself at safety, doing background checks to find our address, making police reports. He's made threats to my fiance, all things that has done between then and now. It's not performative. And if anyone, I don't need anyone.
I didn't say that was performative.
Well, nothing is performative. If my screen is this big, and from here, I can only see her elbow down. I protect my daughter.
Too, baby. And she's still up there muted.
I'm protecting my daughter.
She keeps unmuting herself. Baby,
so I
listen.
say my decision.
Judge, what's her, Attorney Hagler, baby, she cannot keep herself from laughing.
That's what
I
I
will
say.
go to any link at anyone's
She keeps
expense.
getting muted and unmute
Protect
herself.
my
I
daughter.
made my decision.
And he has a warrant.
Order.
You made this decision knowing that he has a warrant here in New York against me and my child. So I'm going to appeal it because he has already violated. He's already violated the New York order of protection. If they wanted to exercise the warrant, they would. Yeah, he has not commenced. He's been evading the police, Your Honor, this entire time. He has a warrant here for a crime committed against me and my child.
Miss Sanford, you're not going to win.
My daughter.
Miss Sanford, there's nothing to win here.
It's not winning. I want to protect my daughter. And you said it was performative. I am protecting my daughter.
There's nothing to win here.
It's not performative.
You will not protect her here.
Yes,
this
I am.
Is what I've said. I've done what I've done. Get me the order.
And I'm going to appeal it. You did this knowing he has a warrant.
I'm not scared of the appellate court.
She's a mess too, baby.
All right, hearing over.
For the things that he has done already to me and my child.
Hearing over.
And I will.
All right. Next.
The judge said next.
Y'all wearing me out today.
Y'all wearing me out today. But I kind of understood what the judge was doing. It sounds like he was just there for like some harassment charge or something like that. So that's the only thing that she can address. And with that one harassment charge that he has, he wants to be able to communicate with his child. Okay, he was harassing the girl, whatever the case is, right? They live in a completely different state. They're hours, miles away, whatever. Yes, he has situations going on in New York, but that is New York's jurisdiction. She cannot make a determination based on their jurisdiction, is what it seems. She can only go by the details of this particular case, what his request is, which is simply just a bond modification. She can hear things from you as to why you feel like you don't want him to have those things. And then at the end of the day, she still can make her decision as a judge, whether she agrees with you or not. And being that these conversations are going to be happening over Zoom and they are going to be heavily monitored, the judge, in my opinion, does not feel like that is any type of, that's bringing any type of, unsafety situation to the child. And should it bring about a safety concerns when it comes to the child, then that could potentially maybe be evidence that New York would want to use in family law. But at this time, she's only dealing with the bond modifications. And right now, that's just what she said it was going to be. All right, but y'all leave y'all thoughts and comments down below. Let me know if you agree with the mother and she's just simply protecting her daughter, or whatever the case, or if you feel like the judge made the wrong call, because I have disagreed with the judge before. I think that it was one case where I didn't fully agree with her on the matter at hand. I do understand her wanting to give the child the opportunity to be able to talk to their dad versus going without talking to their dad. So I do understand that. So, and if he don't reach out and he don't abide by it, then that's on him. It was put out there for him to do. He didn't do it. That's on him. If I guess it would put her in some type of trouble potentially if he was given this opportunity to reach out to the child and then she decides to not interact with him, then I don't know. But y'all leave y'all thoughts and comments down below, honey. That's all that I got for you guys at this time. I'm Jami, that's me, and I'm gonna catch you guys in the next one. Bye-bye.
Yeah, tell him I preach to the choir. Stand with my feet to the fire. Give all the glory to God. Stand in the midst of these haters, I'm silent, nobody can stop me. Just gotta check in my notification, them numbers hit like it's a proxy. Cashed out at the ATM, and the ATL, they done made a gym. I've been kicking doors like the ATF, got them trying to clone me like Agent Smith. Game time, I invaded gym, high elevated, I could face the rim. Putting shots up, I got laser focus, about to take it over, I'm Invader Zim. On a trip to Florida like it's A&M. Who that nigga, man, they say I'm him. Spit the truth, never wasting film, I can feel the pool.